Yeah, so let's start with the bench trial piece. A very big move by the defense to agree to such a thing, and usually speaking, they're going to be arguing a hyper-technical point if they're going to be going with a bench trial, something that they believe a judge would be dispassionate about and may hook onto that maybe would mitigate the sentencing or the charge in the case. Otherwise, why not go with the jury? So he's not wearing the clothes because there's no prejudice. It's presumed the judge is not going to be prejudicial seeing him in his jail outfit. What strikes me as I was looking at this case as a former homicide prosecutor is that when I'm investigating, I got a strong circumstantial case. I got that cell phone being cut off. I got the surveillance videos of him in the area. I got the ballistics evidence that matches his weapon. Of course, I want two other things. One, I don't have to have motive, but I'd like to find out what is the motive. That's certainly where my investigation would be headed, but also during the course of my investigation, because I know I have a strong circumstantial case and I believe I got the right person, I want to head off at the pass with all of my investigation, any potential defenses in the case. And that can range from anything from self-defense, passion provocation, things of that nature. So I think the prosecutors have a very strong case here, and I believe the defense is going for a Hail Mary pass. There's going to be some legal argument down the road that this judge is going to latch onto that may lessen the degree of the conviction.
I agree with everything you said, but I have to ask you about the defendant's demeanor. He's looking down. I mean, they were watching a video of the interview with his parents, and I didn't feel like he moved the entire time. He kept his head down, Bob. You know, I know as a judge, I always paid attention and noticed what defendants were doing, what everybody was doing in my courtroom. But as a defense attorney, does it concern you at all? Would you have instructed differently? Do you think it really makes a difference when it is a bench trial?
Well, first of all, it makes less of a difference, Judge. Really good points. It's more impactful to a jury. But as a lawyer, you've got to be careful when you're telling your client how to dress, how to act. I mean, you have to give general rules, and clearly you don't want them to look terrible, but sometimes it can look scripted too. Look, it looks to me, and I'm just using my 30-year common sense and my life experience, that there is something mentally not correct with this particular individual. And obviously that has been looked into in this case with regard to his competency. So I think he's looking baseline, as we would say as an EMT, right? When I go onto those scenes and I see an individual acting like this individual would be, if I had a family member around, I'd be saying, okay, I know he's off, but is this baseline for him, or is there something different than the way he normally is? I think this is his baseline.
Yeah, I think you may be right. And he may or may not be on medications. We don't know. We know there's competency issues, so we just aren't sure. All right, Bob, thank you so much. We need to get back to court now for more time.